Connect to the world with special Turkish Airlines fares. Book your flight before November 30th and take advantage of great deals. Fly to the most exciting destinations with the award-winning airline that flies to more countries than any other. Terms and conditions apply. For more details, visit TurkishAirlines.com. Turkish Airlines, widen your world.
This episode is brought to you by LifeLock. The holidays mean more travel, more shopping, more time online, and more personal info in places that could expose you to identity theft. That's why LifeLock monitors millions of data points every second. If your identity is stolen, their US-based restoration specialist will fix it, guaranteed or your money back. Get more holiday fun and less holiday worry with LifeLock. Save up to 40% your first year. Visit LifeLock.com/podcast. Terms apply.
Hi, and welcome to Amicus. This is Slate's podcast about the courts and the Supreme Court and democracy and the law and the rule of law. I am Dahlia Lithwick, and that is my beat at Slate. To be sure, we have spent a lot of time in recent weeks on the democracy and rule of law part of that equation, but we thought we'd tack back to the Supreme Court for this week's show in order to preview a case that's being argued next week. United States versus Skrmetti will be heard on December 4th, and it is one of the most important cases on the docket this term, possibly the most important trans rights case to make it to the High Court ever. It would have been a vitally important case, regardless of how the November elections turned out, but with a newly emboldened GOP that comes into office, having campaigned zealously against transgender rights, the court will either fan the flames of that animus or provide some kind of break for it. For listeners whose kids, whose families and loved ones are struggling to adjust to this new reality, the uncertainty is devastating, and this show really is going out with you in our minds. Joining us to walk through the stakes in Skrmetti is Chase Strangio, co-director of the ACLU's LGBTQ and HIV project. Chase will be arguing the case, seeking that the court strike down Tennessee's ban on puberty blockers and hormone therapy for transgender minors. He is probably the nation's expert on trans rights, and Chase was on the show in June 2023 explaining to us how Dobbs had flung open the doors on this kind of anti-trans legislation. Chase is going to split time with the Biden administration, which is also challenging Tennessee's ban. About half of the states have laws on the books targeting trans healthcare, but Tennessee's is among the most draconian. Chase will be the first openly trans lawyer arguing at the Supreme Court. I just want to say welcome, and I also want to say I had really, really hoped that we would be able to preview this case in a very different posture and mood. And so, as I said to you in the green room before we started, you have been on our minds at this show since the election. Thank you for joining.
Thank you for having me. It is nice to be here with you in conversation and really just offering a path forward for how we think about what is coming.
So I thought before we dig in, we really need to mark how destabilizing and terrifying the last few weeks and months have been for LGBTQ Americans, for their families, for you all at the ACLU, for your family personally, Chase. The Trump campaign ran a really, I think, hateful, bullying, vicious campaign. The Washington Post said they spent at least $215 million on network ads, painting trans people as a menace to society. Between October 7th and October 20th, according to Michelle Goldberg at the New York Times, more than 41% of pro-Trump ads promoted virulent anti-trans messages. I know families that are sitting in real fear right now. And I guess I want to just give you a chance to open by telling me what you are saying to people that you are hearing from who are literally trying to decide if they need to move to a different state or a different country or a different school district or a different neighborhood, because this was not just campaign rhetoric. This was a promise.
Yes, it is alarming. It is disturbing. And I see all around me the very real consequences of that. The anticipatory consequences of people not knowing what is coming, but expecting very serious harms to their well-being, to the well-being of their families. And so we have to just hold that this is a very traumatic time for many people, and including the trans community. And we are already seeing these sort of announcements about day one promises from the incoming administration, promises to expel trans service members who have, devoted their careers to that work, possibly losing all of the attendant benefits. Day one promises or week one promises to strip healthcare or attempt to strip healthcare nationally for trans adolescents. Understandably, I am hearing from parents every single day, because this is care that parents are consenting to, that doctors are recommending, that families are relying on, and people are now faced with the potential imminent reality that they will have to leave the country either permanently or on a regular basis, which of course is cost prohibitive for many, many people. And so that is just a devastating reality to sit with. And I am trying to offer sort of messages of hope. Obviously, it's not hope coming from our government, but it is the reality of hope that our communities have faced attacks for decades, for centuries, and found ways to care for each other. I am 42 years old. My young adulthood was defined by gay people being blamed for the 2004 and 2006 elections at a time when it was the centerpiece of the GOP rhetoric leading up to and coming out of those elections, to say that marriage for same-sex couples and same-sex intimacy was the basis for societal collapse. Now, when you look at the material consequences of repeated denials to those benefits versus being denied healthcare, there are real differences, but this is not a new rhetorical turn. We have experienced it directly, and we know how to mobilize against it. I will say one of the hardest things coming out of the last few weeks has been the very swift willingness of Democrats to turn on trans people, particularly when it's hard to imagine the campaign could have done less to center trans people. So to say that Harris lost because of support for trans people when there were almost no words of support out of her mouth for the duration of the campaign, it sends a very chilling message to the trans community.
Before we talk about the case, I want to talk about the law, SB 1. Tennessee enacted it in 2023. You warned us after Dobbs this was coming. It bans surgery, puberty blockers, hormone treatment for the purpose of gender transition for anyone under 18. I would love for you to just, by way of setting the table, Chase, tell us what this law prohibits specifically, what it doesn't prohibit, and what the penalties are.
Yeah, so this is a law that categorically prohibits any medical treatment that allows someone to live, identify, or appear inconsistent with their sex. And it focuses specifically on puberty blocking medication, hormone therapy, and surgery, only when each of those things are prescribed to someone because they want to live inconsistent with their sex. And actually, for purposes of the case before the Supreme Court, surgery is not before the court. So it's just about puberty blockers and hormone therapy. Those medications can be prescribed for any other purpose in Tennessee, but under the law, SB 1, they are prohibited categorically if they're prescribed to allow someone to live or appear inconsistent with their sex. So that is the operative prohibition in the law. The penalties are that an individual doctor who prescribes the medication can be stripped of their license and subject to civil enforcement penalties. There is also a provision of the law that prohibits any distribution of the prohibited medications for the prohibited purposes. That, of course, hasn't been tested, but would definitively apply to pharmacists filling prescriptions and could have broader implications. And then it includes a private right of action, which is not challenged, but I think is important to mention, which is that it extends the ability for an individual to sue for any provision of the medical treatment that caused them harm. And it extends that decades into the future, which is just a very anomalous way for particularly conservatives who generally don't like this type of medical malpractice litigation to extend the private right of action into the future. But again, that's not before the court. The central question is whether this ban on what is in the statute referred to as sex-inconsistent treatments is a violation of the Equal Protection Clause, and specifically whether it amounts to a form of sex discrimination. Two other just quick features about Tennessee's law that I will highlight is that the law announces its purpose of encouraging adolescents to appreciate their sex and banning anything that would cause them to be disdainful of their sex. So that telegraphs, we don't have to guess what the legislature was doing. They tell us what they were doing, that this is about gender conformity.
Right. This is the quiet part out loud provision that
Yes.
And can you just tell us who the challengers are in this case? And I think you've just sort of preempted the next part of that, which is what the fundamental claim is. But walk us through who the challengers are and what it is that they are asking the court to decide.
So we represent three families, three transgender adolescents who were relying on this care in their home state of Tennessee. Their parents, who were the people who consented to this care upon recommendation of the doctors that they work with, and of course, based on the need of their individual children. And then a doctor in Tennessee who prescribes this care and is prohibited from doing so. So those are the private plaintiffs in the lawsuit. Shortly after, we at the ACLU, along with our co-counsel at Lambda Legal and the law firm of Aiken Gump, the United States intervened also defending the same equal protection rights that the private plaintiffs were asserting and intervened in a complaint and intervention against the Tennessee defendants. So on our side currently, though not for long, we have these private plaintiff families, a doctor, and the United States against the Tennessee officials who are charged with enforcing this law.
And just one more beat on that, Chase, because it's so clear that the Biden administration intervened on your side in the case. I think it's abundantly clear what the Trump administration is going to do. There's some reason to believe the court just, why do this now if the administration is going to flip sides? Is that a basis on which you think the court might kick this away?
Well, I mean, the court, of course, can do what the court wants to do. It isn't really a basis to kick it away because ultimately this was a case brought by the private individuals against the Tennessee defendants. So there's adversity. There's still people, parties on both sides of the V, so to speak. The claims have been fully aired and litigated on both sides. The private plaintiffs who we represent have briefed the issue, will have argued the issue. And so they're not stripped of jurisdiction. And in fact, the court is used to, administration switching positions, increasingly so over the last decade. So that is not a basis for them to kick it back. Of course, they could. They can do many things, but that alone, I don't think really changes any jurisdictional or other fundamental questions that bring this dispute before the court. And just to go back to something you asked about the individual litigants, because I think it is so important to center these families, these are young people and their parents who had struggled, as parents and children and doctors do, with this question of how to best treat very significant distress. And one of the things that Tennessee does in its brief is to say, this is all about transition first and ask questions later. And that is just so fundamentally wrong when we look at what is actually going on with these families in these homes. And I, as a parent, and I think any parent can relate, that when your child is suffering, you are suffering. And none of these parents took this lightly. None of these parents knew what transgender was. It wasn't a transition first, ask questions later. It was ask questions and research. Some parents say they felt like they read the whole internet. They spoke to every specialist they could find. And after years, they made these decisions. And Tennessee comes in and says, no, we know better. than these loving parents, even though if your child had another medical condition that was conforming to their sex at birth, you could have these same medications. But we don't want adolescents to live, identify, or appear inconsistent with your sex. And so we're going to take this extraordinary step of displacing these parents' decisions.
I'm going to ask you to walk us through one other technical thing, and then I want to talk about the arguments on the merits. And the technical thing is what happened in the courts below, because it's a little bit confusing in this case. So would you just help us understand what happened in the district court, what happened at the Sixth Circuit, how it makes its way to the Supreme Court?
So when we filed this case in the spring of 2023, we were obviously before the federal district court, the lowest court. We had an extensive record with expert testimony, unwritten submission on both sides. And the district court, as district courts do, on a preliminary injunction, which is the sort of temporary relief in the case, looked at all of the evidence. And prior to the law going into effect on July 1st, issued an injunction blocking the law from going into effect, finding that it likely violated the Equal Protection Clause and then the fundamental rights of the parents. And in so doing, made extensive factual findings about the claims that Tennessee had asserted about the care. And I think just in relevant part said the assertions of harms and their prevalence are simply not supported by the record, and there are significant benefits to this ban treatment. And notably, that was a Trump-appointed district judge who made those findings and in a 60-page opinion blocked the law. Tennessee immediately sought to stay that decision. So put a pause on the injunction, which would allow the law to go into effect. And so went up to the Sixth Circuit Court of Appeals. The court granted that very shortly after, within 10 days of the order, saying, we're staying this. We think Tennessee is right, and we're going to set this for an expedited briefing and argument on appeal. So we had, in the summer of 2023, a very rushed briefing scheduled before the Sixth Circuit on appeal. At that point, the law was in effect. And by the end of that period, in September of 2023, the Sixth Circuit, in essence, issued the exact same opinion that it had issued on that stay and reversed the district court's decision. Now, two important things about that. The first is that the basis for reversing was that the Sixth Circuit said this isn't about sex, that this is not a line that actually draws distinctions based on sex. It's about something sex neutral, and therefore we can defer to the Tennessee legislature. Because if it's a sex classification, you get this heightened standard of review. So that's one thing. And then because of that, the Sixth Circuit never looked at the factual findings, just sort of disregards all of that work that the district court judge had done to say Tennessee's claims just aren't supported. And the Sixth Circuit says, doesn't matter, legislature can make these decisions. And this is probably familiar for people following the abortion fight, because that was the essence of the question with respect to overturning Roe, which is there some heightened level that the government has to meet to justify banning this healthcare or not? And ultimately in Dobbs, they say not. We defer to the legislature. And that's precisely what the Sixth Circuit said here. And so at that point, we had this decision, catastrophic as it was for Tennessee, but it also set off a chain reaction of other decisions, allowing other laws to go into effect. And not only that, it set a precedent that would, in my view, open the door to the next set of laws banning care for adults. And so at that point, there were two cases at the Sixth Circuit at that point from Kentucky and Tennessee, and then, of course, the intervention from the United States. All three groups asked the Supreme Court to review the Tennessee litigation with the private plaintiffs in the United States, and then also the groups from Kentucky.
Let's pause to hear from some of our great sponsors.
This episode is brought to you by NRDC. We all know by now that Trump was elected president, and one thing is paramount. We must fight for our planet. The Natural Resources Defense Council, NRDC, is fighting in and out of court to protect the environment, public health, and climate progress from Trump's Project 2025 agenda. NRDC has done it before, and with your help, they'll do it again. During Trump's first term, NRDC filed over 150 lawsuits against Trump's administration and won almost 90% of resolved cases. And this time, they're ready to fight even harder. Despite Trump and his allies' best efforts to pull society backward again, NRDC will work every day to not let them stand in the way of progress. Your support is critical right now. NRDC is not giving up, and with you, they can safeguard our planet for future generations. Donate now at nrdc.org/podcast. All gifts matched for a limited time.
If you read the headlines about what's going on in Israel, you get a tiny slice of a very long and complicated story. For more depth and historical context, that's where the podcast Unpacking Israeli History comes in. If you have ever wanted to know more about what Israel is all about, from multiple angles and viewpoints, this is the podcast for you. Unpacking Israeli History, hosted by self-confessed history nerd Noam Weissman, goes behind the scenes of Israeli history and dives into the fascinating and sometimes controversial events in Israel's past and present. Noam examines each topic from a variety of perspectives, leaning into the complexities and layers around topics like how the State of Israel was founded and the debate around the Israel-Palestinian conflict. The goal of Unpacking Israeli History is steadfast, to provide listeners with a nuanced, fact-based understanding of Israel's past that is both informative and entertaining. So educate yourself, learn the history behind the headlines, and find Unpacking Israeli History wherever you listen to your podcasts or on YouTube. Let's return now to my conversation with Chase Strangio from the ACLU. So I think you've just said it, but this is the sort of guts of the thing, is whether you're going to be able to define this as the language of gender discrimination on the basis of sex, or whether you're going to say it's this other thing, which I want you to talk about. But, we've had a half a century of understanding, I think, of what it means to discriminate on the basis of sex. So maybe you can sort of pick your case that you want to start, but maybe it's United States versus Virginia in 1996. But we, for a very, very long time, I think, have been pretty clear what sex discrimination is.
Yeah. And I think it might be helpful to go back much earlier to say that for hundreds of years, there was sex discrimination on the books in the United States. And that sex discrimination, by and large, was justified based on claims of biological differences. And those claims of biological differences were used to justify things like prohibiting women from working overtime, prohibiting women from working as bartenders. Prohibiting women from...
My favorite case. Okay, go ahead.
Bartenders, unless your husband owned the bar,
right.
And prohibiting women from being lawyers. Those cases were justified based on claims about biology. 50 years ago, the court says, you know what? This seems wrong. And we can point to Pauli Murray and Justice Ginsburg, who convinced the court that the language of the Equal Protection Clause protects against the type of overbroad generalizations about how men and women are, and that the court should require the government to actually show it has a good reason for making these distinctions based on sex. And for 50 years, that has been the rule. And it has been reinforced time and time again. And in United States versus Virginia, which was about admission to the Virginia Military Institute, which excluded women, the court again said all sex classifications get this heightened level of scrutiny. And it specifically recognized that most women do not want to join the Virginia Military Institute. But they said, and they used this specific language, that what is true of the average person cannot be used to discriminate against the person who falls outside the average description. And that is why we have this heightened scrutiny, in essence, because it has, as the court has said, a constraining impact. And so here we have a law that says you cannot do something if it departs from what Tennessee thinks you should do based on your sex. That is what this law says. It says no treatment if it is for the purpose that would allow you to live, identify, or appear inconsistent with your sex. And Tennessee says, well, that's not about sex. And we say, oh, yes, it is. And the argument that Tennessee puts forth, by and large, and that the lower court accepted on some level as well, but it treats everyone this way. Neither males nor females can undergo gender transition. And our response is sort of twofold. One is, what do you think undergo gender transition is, if not a rule about sex? And then the second point is that in Bostock, just 4 years ago, the court said it is no answer to firing a trans woman to say you would also fire a trans man. That rule is just discriminating twice over. It's not neutral on its face. And the same is true here.
So Bostock is the thing that makes it hard to understand how the Sixth Circuit got where they got to, Chase, because in some sense, Bostock is a Title VII case. This is an equal protection case. But Bostock already decides that discrimination against trans employees is discrimination on the basis of sex, right? Done and dusted. And I just would love for you to explain to us, and let's just explicitly say, written by Justice Neil Gorsuch. Chief Justice John Roberts agrees with the reasoning. The notion that this is untraveled ground goes away after Bostock. And yet, here we are. And I would just love for you to explain how the Sixth Circuit gets around it.
So the Sixth Circuit decides, and this is a departure from all other cases in which the court doesn't do this, but the Sixth Circuit in essence says, well, Bostock is just about Title VII. It is just about the statutory context in which people are prohibited from discriminating in employment because of sex, and says it's based on the particular language of that statutory protection. The problem with that is that, yes, Title VII and the Equal Protection Clause are different. Everyone agrees about that premise, but they're different in terms of what is ultimately prohibited, not insofar as what is identified as because of sex. If the funeral home in Bostock was a government employer and that government employer fired Amy Stevens for being transgender, the court wouldn't have said that, well, it is because of sex for Title VII, but it's not because of sex for the Equal Protection Clause, because both provisions are about protecting individuals. And they make a big deal about this in Bostock, that Bostock is about the individual. But guess what? So is the Equal Protection Clause. It refers to any person. And for the originalists on the court, that provision of the Constitution was designed so that people were treated as individuals, not just as members of classes. And so they have that in common. And then the other piece is that, Title VII asks, would the outcome be different if you were of a different sex? Well, so does equal protection. It asks, would the outcome be different if you were of a different sex? And so the logic of Bostock applies to the Equal Protection Clause. And I think you have to do a lot of distortion to suggest that somehow a sex line becomes sex neutral when you're looking at it through the lens of the Equal Protection Clause.
You've slightly said it, but I would love to have you give the most charitable iteration of what Tennessee is saying in defense of its law. I mean, I have to say, it's hard to read the brief because it's like, Europe, bad, we found a doctor. Give me the most, if you can, compelling argument for what Tennessee says they're doing here. And I know, let me also be really clear. You said that it starts from the premise that people make wildly reckless, unresearched decisions about their children.
Right. That is sort of the underlying premise. I do think it's hard to come up with a grounded doctrinal explanation of what they're arguing, because even if you take everything they say about Europe, which we fundamentally disagree with and the record doesn't support, or the risks of the treatment, that simply does not change that it is a line based on sex. So that is still not answering the question of sort of what has Tennessee done, if not ban treatment because of sex. So that piece of it goes to whether that line is justified, and we obviously disagree about that piece. The way they claim that this is sex neutral is in essence to say, we're just banning a medical procedure, not something based on sex. And this isn't about men and women being treated differently. And I think that really is the crux of their argument about why the heightened scrutiny standard that attends to sex classifications doesn't apply here. And from my perspective, it's really hard to reconcile that with the text of the statute and the Supreme Court's precedent. And somewhat puzzlingly, Tennessee even says in their brief that a law that bans sex-inconsistent dress would be a sex classification. A law that bans sex-inconsistent professions would be a sex classification. And this is just a law that bans sex-inconsistent medical procedures. And so it is not clear to me how you get from those points about those other hypothetical laws to saying that this is not a law that imposes disparate treatment based on someone's sex.
There's one other piece of this that I'd love for you to poke out with me, which is it's not just an argument about the civil rights of trans youth, but there's this argument about the rights of parents to make medical decisions about their children's care that is kind of the beating heart of substantive due process. It's the beating heart of how we think about, family autonomy and privacy, and everything that we have protected constitutionally goes to this notion that parents get to make their kids' medical decisions. It is why we have judges who are saying, parents get to decide if their kids can have an abortion or use contraception. So how do you get around? I'm not asking how you get around it. It is very, very strange to have Tennessee taking the posture that the state actually gets to override this parental interest in making medical decisions about their kids.
I completely agree. And of course, we have a due process claim on behalf of the parents that is not before the court because they did not grant that question. But it bears on the equal protection claim because at the end of the day, Tennessee is claiming that they are doing this to protect children. But who do they otherwise expect to protect children and weigh the risks and benefits of potential medical treatment if not the parents? That is the role of parents traditionally. And Tennessee is coming in and displacing the aligned judgment of an adolescent, that adolescent's parents, and that adolescent's doctor. You have on one side the adolescent's parents, the adolescent's doctor, the entire mainstream medical establishment in the United States, and on the other side you have the government of Tennessee. And as you note, it is quite stunning to see state governments like those of Tennessee and Alabama and Arkansas all of a sudden arguing that parents' rights don't mean anything because these, of course, are the same governments that have aggressively asserted the rights of parents to, for example, not have to have their children mask in school, not have to have their children get vaccinated, not have to have their children learn about other people in their school history and other classes. So, of course, this is quite an about face for those who have been robust defenders of parents' rights to come in and say, but not these parents who are loving and supporting their trans children and making the same types of informed judgment that parents make every single day in complex medical decision making, because that is what we do. We know our children best. We are the ones who are incentivized to do the research to ensure that our children get the care that they need. And Tennessee has come in and decided that they know better.
Right. I just think it's such a poignant marker of where we are, that after years, as you say, of hearing parents know best, get the state out of my kids' reading list, get the states out of my kids' sex education, get the state out of my kids' masking mandate. But parents know best until and unless the state disagrees with them, which is in this instance. And it's really a shattering inversion of how we think about how families make decisions. Chase, after Dobbs came down, you were on the show with a kind of clarion warning about how the Dobbs decision had just rocket-fueled anti-trans legislation across the country, and a real, I think, straight line that you drew between what had happened in Dobbs and what we were missing if we weren't connecting it to the trans bans. And I would love for you to just remind listeners why Dobbs was never just about abortion.
I mean, there's so many reasons, whether you look at the equality thread or the autonomy thread in Dobbs. This is about structural efforts to impede people's abilities to make decisions for themselves. And so the way in which Dobbs opened that door in particular for these anti-trans bans is that first, they revitalized this case that we know Justice Ginsburg hated and we know was really never really talked about for a long time, called Godoldig. And Godoldig was the case in which the court said that restrictions on benefits related to pregnancy are not sex discrimination. And it sort of allowed for this idea to sit dormant for quite a while, but to be reactivated by Justice Alito and Dobbs, which is that when we're talking about things related to medicine or health or areas where we can claim that biological differences between men and women justify some differential treatment, we are going to start to erode those general protections that we have worked so hard to build for sex-based protections under law. And to my mind, what is happening here in the 2.5 years since Dobbs was decided is that you have people who have long wanted doctrinal openings to roll back anti-discrimination protections, finding a group of people for whom there is more public support to target, and then using that to open the door to big possible doctrinal gaps in how everyone can be protected from sex discrimination. And I see this happening very strategically. Within a week of Dobbs being decided, it was cited in every single anti-trans related case that we were litigating. It was cited for the proposition that, in essence, special deference is owed to legislatures when they are regulating in the area of medicine when it deals with sex-based differences between men and women. And if we take a step back and look at this moment we are in and the obsession with trans people during the 2024 elections, it wasn't really about trans people. What it was about, the organizing theme, was about gender roles more broadly. And this is where they are using these attacks on trans people to re-entrench old notions of what is the proper role of men and women in society.
It's interesting, as you're talking, Chase, one of the things I'm also really reflecting on is that the 2 abortion cases last year, both mifepristone and the EMTALA case, in a lot of ways were not about abortion. They were about physicians and their rights and what kind of care they could give. And it is so striking to see a case now that's like, oh, we don't care what the parents think or what the physicians think. It really is amazing that just as the parents are always right until they're wrong, physicians are also always right until they're wrong. And it really feels as though that's a through line that we are seeing of like deep trust and reification of parental roles and physician roles until and unless those parents and physicians make decisions that the state disagrees with. So it's not just that, it's an entrenchment of gender roles. It's this notion that doctors are the only kind of important autonomous actor in the abortion context in both cases last year. But now they're just irrelevant. They're wallpaper.
Yeah. And not only that, there's this stunning thing that we've seemingly just accepted as a matter of public discourse, that not only are they wallpaper, they're part of this vast and far-reaching conspiracy to provide harmful care. We're talking about care that is supported by the American Academy of Pediatrics, the Endocrine Society, the American Medical Association, the doctors who are providing it at the most preeminent research institutions in this country. And somehow the argument is they're all conspiring to provide harmful care to minors. And if we take a step back, that is quite a conspiratorial argument. And whatever people may disagree about or feel discomfort about, these are still good faith parents and doctors trying to do right by their patients and their children. But yet we've somehow allowed this conspiracy to fester that actually everyone is just trying to provide harmful care, which is just absurd.
It's interesting. I was going to ask you about junk science and bad data, which has been like, if our show has a major in the Supreme Court, our minor is like junk science. And this, as you say, you just listed just a tiny number of amicus briefs suggesting that medical and mental health groups and, serious scientific entities, this is not something they haven't thought deeply about. All these professional organizations are right on one side. And then, as you say, on the other side, the Tennessee brief is just like teeming with weird deep state conspiracy theorizing. And I worry because, as I say, this is my minor now, about junk science that infiltrates court doctrine, that makes its way into opinions and then gets cited as though that junk science is real.
Yeah, it's really scary. And I think it's also a function of the fact that the courts no longer really care or look at factual findings of the district court. They will just pull out the latest newspaper article that they see. And there is an actual purpose to testing the evidence and seeing whether it holds up, because when we've gone to trial in these cases and these witnesses are cross-examined, they have admitted that they're exaggerating, accepted that there's no underlying scientific support for claims that they are making, pointed to the fact that perhaps it is speculative or based on internet searches or Reddit sites. And so this is why when we look at the outcomes of these cases in the district courts where the judges are the closest to the evidence, you have almost a, unanimous set of holdings when heightened scrutiny is applied that these laws just don't hold up. When you get more detached from the evidence and it becomes more about vibes, for lack of a better word, it becomes very untethered to what is actually going on, which allows people to say things like, well, there's no long-term studies. Well, there are long-term studies. There's studies that are tracking people for periods like 6 years, which is extraordinarily long in pediatric medicine, and taking snippets of ideas out of context and not situating it in how pediatric research actually happens. And I think that's where we find ourselves now. This medical care isn't new. It's been provided for decades, and that isn't new in medicine. Think about all of the innovations, even in just the lifetime. I have a 12-year-old in my child's lifetime that we've witnessed. And so I think that is just so much distortion and out of context polemics.
Right. And this is, again, call back to the mifepristone case where, the challengers were like, no one has ever attempted to use these medicines before, even though there's decades of research. We are going to take a short break.
Hey, it's me, the Quenchies. I'm that late afternoon craving you just can't shake. Wait, what's that? Welch's Grape Aid? No!
Made with real fruit and no added sugar, nothing answers the call of the Quenchies like Grape Aid. Got the Quenchies? Grab a Grape Aid in your juice aisle.
Stop. 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 Had enough? Kick out mucus and quiet the cough with Mucinex 12-Hour DM for long-lasting cough and chest congestion relief. Buy Mucinex 12-Hour DM at your local retailer. Use as directed.
And we are back with co-director of the ACLU's LGBTQ and HIV project, Chase Strangio. If our show had a theme song, I guess we do have a theme song. If we had a different theme song, it would be Sherilyn Ifill, who comes on the show every 6 months or so and says exactly what you just said, Chase, which is this how we do law now, right? If you're just going to ignore the district court findings, what is it that civil rights attorneys are doing amassing these trial court records? And I think you've just made exactly the same point. There is a substantial record here. And the Sixth Circuit doesn't much seem to care. I find myself wondering what you think is going to happen when Justice Gorsuch and Chief Justice Roberts have to grapple both with Bostock, which we've discussed, and Tennessee's kind of sort of inability to name a very high state interest here. That's why they have to get it down to rational basis. What are you thinking? You mentioned originalism and the plain meaning of the words. What are you thinking might persuade them here?
I think the language of the statute is persuasive. It is telling us that this is about inconsistency with sex, and that this court has said in Bostock that if you fire a man for being insufficiently masculine and a woman for being insufficiently feminine, that is sex discrimination. And that is precisely what this law does. No treatment if it's insufficiently masculine, no treatment if it's insufficiently feminine. And so, I want to believe that looking at that plain language of this statute and this court's precedent, which has for decades gone out of its way to adopt anti-classification principles, which I also think is important. If you look at the affirmative action cases, for example, the entire premise of them is you can't know whether a line is benign or nefarious just by looking at it. All race classifications get strict scrutiny. Now, I can disagree with that premise, but that is the guiding principle that this court uses. And that is exactly what it means to apply heightened scrutiny when a law uses race or sex on its face to draw distinctions between individuals. And so, I think they have to do a lot of contorting to not see that in this statute. So focusing on the language of the statute, what this court said in Bostock and what it said in 50 years of equal protection cases. And then hopefully if there is sort of a thematic background set of principles that will come forth and can come forth in this argument, it is that this is not the federal government displacing Tennessee. This is Tennessee displacing the loving, reasoned, painstaking decisions of parents who are trying to do right by their children, who were in anguish and are now doing better because of the healthcare that Tennessee now bans.
Chase, you started this discussion with a mention of just what's happened in the last couple of days on Capitol Hill. Speaker Mike Johnson announcing a rule change that will bar trans people from using the appropriate single-sex bathrooms in the Capitol. This is passed immediately after Sarah McBride of Delaware becomes the first openly trans individual elected to Congress. President-elect Trump, as you said, we're hearing reports preparing to issue an order right after inauguration immediately to ban trans folks from serving in the military and medically discharge thousands of trans service members who are serving in the armed forces. Nancy Mace now says she's filed a bill that would ban trans people from bathrooms aligned with their gender identity in every federal building. I don't even want to ask you how that feels, knowing that you're going to be arguing at the court next week. But I find myself really wanting you to dig deep and tell me what it is that you learned in your 4 years litigating against the first Trump administration that you can draw from, that you can, in some sense, rely upon as you think about what litigation is going to look like in the 4 years ahead?
First of all, the Representative Mace bathroom, with Speaker Johnson's policy that is so cruel on its face and targeted at Representative-elect McBride, it just shows you that this is just a cruel, misguided escalation that is just only going to get worse. And I think one of the things that I point to in this moment is in Tennessee's brief, they argue and say that it blinks reality to suggest that trans people do not wield political power. And I'm just thinking, what planet are you living on? We have exactly one person elected to Congress, and before she takes office, they ban her from the restrooms. And with that, all staff who are trans, constituents who may want to come meet with their elected representatives. And so this set of attacks is extraordinarily far-reaching and has such a ricocheting effect on all aspects of trans life. So I will say that this is worse than it was in 2016 by a mile. And the anti-trans rhetoric has expanded dramatically. But if I look to where we were at the ACLU in 2017 through 2021, particularly with my colleagues in the immigration rights space, in the abortion space, it was an everyday set of attacks. And people had to gear up and fight those. And they did so incredibly alongside organizers who were ensuring that we were building movements on the ground. And I think that is the lesson to move forward with, that yes, we will plan litigation to try to delay, and if we can, stop these extraordinarily harmful government assaults on our lives. And also, we are doing that with the understanding that there will be robust movements taking care of our communities. And so I do this legal work knowing that the real work of keeping people well and alive is happening in the organizing space. And then the other thing I'll say is that we need to help people understand that you should care about trans rights and trans people because we should care about our fellow human beings. And also, these attacks on us are also about you. Because at the end of the day, if there is a ban on trans people using the bathroom, we are a very, very small minority in this country. The people who are going to be disproportionately affected by that are the gender nonconforming cis people who all of a sudden get policed in the bathroom. And if the Supreme Court rules in favor of Tennessee and opens the door to further erosions of our equal protection principles, yes, that is going to be devastating to trans people. It's also going to be devastating for everyone. That there is a movement to erode bedrock constitutional protections, and they are using us as trans people to get at rights for everyone. And I want people to join in the fight because we are all affected by what is happening, and that if they come for us, they are coming for you too.
Chase Strangio is co-director of the ACLU's LGBTQ and HIV project. He will be arguing the case Skrmetti next week at the Supreme Court. I can imagine you have a lot of mooting to do, so get out there and do it. And thank you so very much for giving us your time this week and for your work always.
Thank you, Dahlia. It was great to be here with you.
That is all for this episode of Amicus. Thank you so much for listening. Thank you so much for your letters and your questions and your thoughts. You can always keep in touch with us at amicus@slate.com or find us at facebook.com/Amicus podcast. Do not miss today's episode of Amicus Plus. Mark Joseph Stern is back from his taycation, and we're going to invite you to join a Slate jurisprudence editorial meeting of sorts. We wanted to share some of what we have been thinking through at the edit side in terms of how to cover the courts and the law and the rule of law under Trump 2.0. And we actually really need to hear your thoughts on this too. You can subscribe to Slate Plus directly from the Amicus show page on Apple Podcasts and Spotify, or you can visit slate.com/Amicus Plus to get access wherever you listen. That episode is available for you to listen to right now. We will see you there. Sarah Birmingham is Amicus' senior producer. Our producer is Patrick Fort. Alicia Montgomery is vice president of audio at Slate. Susan Matthews is Slate's executive editor, and Ben Richmond is our senior director of operations. We will be back with another episode of Amicus next week. We wish you and your families a happy Thanksgiving and a happy start to the holiday season.
If you're a maintenance supervisor for a commercial property, you've had to deal with everything from leaky faucets to flickering light bulbs. But nothing's worse than that ancient boiler that's lived in the building since the day it was built, 50 years ago. It's enough to make anyone lose their cool. That's where Grainger comes in. With industrial-grade products and dependable fast delivery, Grainger can help with any challenge, from worn-out components to everyday necessities. Call, click Grainger.com, or just stop by. Grainger, for the ones who get it done.